thanks everyone for joining today. Happy to be live with Courtney Posner. And if you're launching a fund, she's the woman you need to talk to. Courtney, please tell us about yourself.
Wonderful. Thank you so much for having me. I'm thrilled to be here. I'm Courtney Posner. I'm a partner in the Lowenstein Sandler Investment Management practice. I sit in our New York office. Just a few words about Lowenstein. We are a national law firm. We are a full service law firm with, very robust transactional litigation, restructuring practices. And our IM practice is a very important practice to the firm. Oftentimes, really a gateway to many of our other practice groups. Our IM practice really sort of covers all different types of funds, different strategies and different structures. And my background is that I spent really a large portion of my career in-house, most recently as the general counsel and chief compliance officer of a hedge fund in New York. Before that, I was in-house at a large multi-strat investment manager where I focused on fund of funds and secondaries funds. And so my background, similar to our practice, is kind of broad and covers different types of funds, closed end, open end. I think today's discussion, we're going to focus more on the closed end emerging manager style funds. But, what I do is I do fund formations and I build investment management businesses and I advise them throughout that entire process, as well as with respect to their ongoing operations, as well as with respect to regulatory compliance as well when that comes into play.
That's a lot.
It's a lot.
But we're lucky to have you here. And for emerging managers, it's really important to start your fund on the right foot. And so Courtney's going to talk about, basically from day one, what you need from your formation return.
Yeah. And so I think the good place to start in terms of funds and like funds 101 is to think about the cast of characters when, forming your fund. And, that really sort of starts with your management company. That is like the heart of your business. That is the place from which you are going to operate. That is where you are going to hire your employees. That is where you are going to develop your intellectual property. That is where you are going to sign your lease. And you are going to sign service provider agreements. And ultimately, that is the entity that will be responsible for managing your fund. Okay, so we've got the cast of characters, right?
Yes.
And through an investment management agreement, often called an IMA, the investment manager will manage the fund vehicle. Oftentimes, what we see is an investment manager that is set up as a Delaware LLC. The fund is typically like a Delaware LP. That's a common, structure. And just taking a step back, your structure is going to be driven by who your investors are and what your investments are. There's oftentimes, very complex tax considerations that come into play. And that is something to not be taken lightly.
Right.
But just, kind of high level, what's very typical, what many investors are used to seeing are, these entity types.
Yeah.
And Delaware is very friendly from an incorporation perspective, and well understood. And so, you have your fund, and that's the vehicle where your third-party capital is coming in. That's where, you are going to have, your negotiations around terms. And that's the vehicle that's going to be making the investments.
Right.
When you organize as a Delaware limited partnership, you have limited partners and a general partner. The limited partners are the third-party investors. The general partner is typically an affiliated entity of your management company. That is a separate entity that, is formed and usually receives the performance compensation, separate from a management fee, which goes to the investment manager.
Or carry, as we
carried interest,
yes.
Exactly.
Yes.
And why? Why do you separate that out? There are a couple of main reasons, but for liability purposes, you really don't want to have that carried interest going up to your investment manager. You kind of want to have it segregated in its own entity, so that if
there's no
claims and cross sort of liability with respect to that. And so, when you think about the fees that are paid by a fund, you think about a management fee and you think about carried interest. and the management fee flows to that investment manager. And that is really for the purpose of paying your employees, keeping the lights on, running the business. And then the carried interest is really, a share in the profits of the fund's investments. And that's where the real money's at.
Right. There, the general partner is really not, the management fee is nice, but they're looking to get their carry, which means their investors are happy. So
Exactly. It's an alignment of interest.
definitely.
And the management fee is necessary to manage and run the business and pay people and keep the business going. But people are not looking to get rich off the management fee.
Right.
That's not the structure. Now, a lot of the times, and we can get into specifics on terms of the funds, but a lot of the times what you'll see with the management fee is in a first-time fund during the investment period, in order for the manager to kind of get up and running, you're going to have a higher fee
Right.
during that period to kind of kick things off.
Right.
In terms of documentation, the key documents are a private placement memorandum.
Right.
That is your offering document. That's not necessarily a legal document, but what it's going to have is a summary of your key legal terms that are going to appear in your governing document. It's going to have a description of your investment strategy and process, and then a discussion of the key risk factors applicable to that. And that is really important, for purposes of, meeting the requirements of all the regulatory regime that we're operating under. It's a private placement regime. You need to make sure that you have the appropriate risk factors and conflicts of interest disclosed. This comes back to, regulatory requirements and risk.
Right.
And it ultimately investors understanding what they're getting into.
Transparency.
Totally. And then the governing document that typically is at play is the limited partnership agreement, because it's a limited partnership,
Right.
right? The fund. This is where you're negotiating with your investors. This is where, all of the key terms of the fund are housed, from the start to the finish, the powers of the general partner, the general partner's delegation to the investment manager of certain investment management, services and the mandate.
Yeah.
And then, of course, structures the management fee payment to the investment manager. It's going to lay out your investment restrictions. It's going to lay out how you can call capital when. It's going to lay out the period during which you can raise funds, do fundraising, and then, how it works when you have people coming in at later closings, and do they pay, interest,
Right.
and,
Catch up interest, or
so that they are put in the shoes as a day one investor. The plumbing in terms of capital contributions, what they can be used for during an investment period, after an investment period. And then, of course, what do the distributions look like? When must they be made? What is the distribution waterfall, right? Who's getting what?
right.
And then ultimately, it will cover things like indemnification, transfers, which there's very limited liquidity in these funds. So very specific situations under which you can transfer, and usually requires a general partner consent. And then ultimately, like the winding up, the term winding up. And of course, it will cover reporting, all the transparency that, is applicable for the particular fund.
Can you talk about GP friendly versus LP friendly documents,
Yeah.
and usually which scenarios they come to play?
Look, I mean, I think for an emerging manager, you're sort of, you start off in a position of trying to win capital, right? You're trying to win investors and lure them in. And at the same time, you don't want to give away the store. You're trying to set up your business in a way that's going to sustain and stand the test of time.
Right.
And so, we had a couple of questions come in.
Yeah.
About, how do you get the capital in?
Right.
And what does it mean when you agree to certain terms in Fund 1 with respect to what's going to happen in Fund 2?
Right. Specifically for like an anchor that, or the first big commitment, right? They usually have terms that they want to put in.
Absolutely. And they're going to dictate those terms, and they're going to dictate the structure.
Yeah.
And so it could mean that, and this is probably the best case scenario, where they're saying, okay, we're going to make the investment directly in your fund.
Mm-hmm.
And we're going to say to you, we're a seed investor. We're giving you a lot of money. We want preferential fees. Maybe we want better liquidity. Maybe we want better transparency. We definitely want a most favored nations provision, which says that to the extent you bring someone else in with better terms, we get those terms, right?
Yeah.
And that's
I
something.
never knew what that was actually.
Okay, so that's and that's side letters.
Yeah.
That's a big thing. That's
Yeah.
we're kind of getting a little off,
Oh,
you know,
yes.
all over the
Off
place
beaten
with the
path.
documents. But this the side letter discussion is a corollary to the LPA discussion.
Right.
Because what happens is investors come in and they might ask for very specific terms, and you might not want to give them to everybody, and so you put that in a side letter.
Got it.
MFN is like provision number one that people want in a side letter. A lot of managers take the position not giving it.
Right.
I think a new manager who's trying to get capital in might not forget it.
Yeah.
And it's not uncommon. And these are bespoke and heavily negotiated provisions. Sometimes, you know, they're size-based. Sometimes you're going to say that, you know, you have to take a package, right? Like if you're getting the good and there's been other provisions that have been negotiated, you got to take the good with the bad.
Yeah. It's what you can live with.
That's right.
And it's also, you have to be careful because you don't want it flowing into fund two sometimes.
Exactly. And so, you know, you think about all these things when, you know, kind of what can you live with? What is going to get your fund off the ground?
Yeah.
Where are you going to be able to establish some momentum to get others in after the fact? And so, you know, it's very important to think about, you know, what are the preferential terms you're giving? That's at the fund level.
Right.
Sometimes a seed investor is going to come in and they're going to want a GP stake.
Right.
They're going to want a piece of, you know, the general partner as well. And like that income stream or that profits interest. You may have other situations where someone comes in and wants actually like a revenue stream from your management company and has some rights with respect to management company. I think as you get into some of those upper tier entities, you have to be very thoughtful and very careful because those are the ongoing implications for your business. That's not just with respect to fund one, maybe that could be forever.
Agreed.
And so that's something to think about. The other thing I would say, just on the, you know, thinking about bespoke arrangements for investors and getting them in the door, getting them comfortable, is the structuring. Sometimes they don't want to go into a commingled fund. I'm seeing more and more now managers who are emerging managers have to kind of do the dance with respect to like separately managed accounts.
Right.
And sometimes separately managed accounts can take the structure of a fund of one, but they're still then saying, here are the specific investment restrictions and terms that are going to apply to me.
Right.
Maybe in a fund of one, we don't want to have to be responsible for the admin as much.
Right.
And we'll let you do that. And you'll get, you know, certain benefits from a tax perspective with respect to the income streams.
Right.
But, you know, at the end of the day, we don't want to be commingled. We don't want to agree what everyone else is going to agree to. We want our own terms. Sometimes people will go even further down the line and say, I don't want to be in a fund structure at all. I just want a separately managed account. And, you know, you'll follow the guidelines of that account and we will have full transparency and the ability to pull the account at any time, right? Or at a set time that's maybe better than the fund.
Right.
And managers will agree to that as well in order to start getting capital in the door and making investments.
Right. Makes sense. Going back to the LPA for a second, can you talk about the different two types of carry models? You generally it's either American or European.
Yes.
I'm just curious if you can, you know, give a little more information on that.
Right. So a traditional European waterfall is going to be a full return of capital before the general partner starts to share in any of the upside.
Yeah.
An American waterfall is really an investment by investment structure where they, you know, investments are realized, the capital comes back and flows through the waterfall and they can take their profits, their carried interest at the time of each investment being realized.
Right.
What can happen there is that you might get to the very end.
Right.
And, you know, some investments were very successful and others were not.
Yeah.
And you're in a situation where the GP's got to pay too much.
Right.
And that has given rise to another very important provision in the documents called the clawback.
Yeah.
And that's another very heavily negotiated provision and important to investors who are sophisticated to make sure that at the end of the day, everything is appropriately worked out in terms of the economics and that there's actual teeth to that provision and they can go after the people who have received the carry and claw back the money.
I mean, I've seen a lot more aggressive language when it comes to that because I think in the past, you know, the general partner could just basically if they took carry up front, they would have to give back the after-tax dollars.
Right.
But now it's limited. The language is even limiting it further to like specific tax amounts that you can actually use.
Yeah.
So the GPs, the LPs are definitely aware.
They're savvy.
Yeah, they're very
They're
savvy.
very savvy. And, this was, something that I dealt with all the time while in-house too.
Right.
Helping the people on the finance team and the admins interpret the language.
Right.
Right? Because
Oh, yeah.
it's so important for the lawyers to be very careful about what they've written down because it goes off and no one knows what the intention necessarily was. And there could be more than one way to interpret something.
Yes. I'd like to call it lawyerish.
Yeah.
Instead of English, because you guys speak in your own terms.
Legalese is what we like to call it, but
Yes,
that's
legalese.
lawyerish.
We're like, what, just say English, right? But the way you guys write it, it needs to be interpreted. So now we understand the fund, we understand the LPA, the PPM, the management company agreement. What else is there?
The other key document, subscription document.
Right.
Okay, so this is the document pursuant to which the investors actually commit to the fund. And in this document, they lay out what their capital commitment is.
Mm-hmm.
They lay out certain representations about their sophistication and, eligibility to be in the fund. And the fund relies on these to meet certain offering exemptions,
Right.
which are very important from a private placement perspective.
Yeah.
I think the other key thing that, and I guess maybe just to go into a little more detail with respect to that, because people hear a lot of these terms. Accredited investor is a term under the Securities Act, and that's to, that's with respect to offering of securities, and you're offering securities in the fund, and you want to offer them to accredited investors to be able to rely on certain, safe harbors.
Right.
Okay. And that standard is, a lesser standard than a qualified purchaser in terms of assets under managed or assets that you have, right? Investments that you have personally.
Right.
If you are an individual or, if you're an entity, it's a larger threshold. And what it means though, ultimately is that under the Investment Company Act, which is another applicable body of law,
Right.
To the fund itself. And so that it is not considered an investment company, you have to rely on certain exemptions. And so to rely on an exemption called 3C7, which allows you to have an unlimited number of investors, the sophistication level of your investors must be higher. And that's a qualified purchaser.
Got it.
If you're not going to be able to bring in, and I think for these emerging managers and smaller funds, you may not be at that place. Okay. And so you may be not at a qualified purchaser standard. You may be looking at the accredited investor standard, which is a lesser standard. You, though, for 3C1 purposes, can still do an offering. That's the exemption also that people typically rely on. It's 3C1 or 3C7 under the Investment Company Act. But there's a limit to 100 investors under 3C1.
Is it 100 or 99? It's 100?
It's 100.
Okay.
And yeah, you can go up to 100.
Got
it. And so these are the types of representations that are made in the subscription document.
Yep.
And that's also the document where you're going to have a lot of representation around KYC and AML, and tax.
Yep.
And that document usually has an attachment, like the tax withholding form that investors are going to be required to provide. And that's sort of the package that they give to the fund with all their information. And then it may mean that there's like a back and forth of you ask additional questions and get what you need. The fund just kind of get what they need for the investors. And then ultimately the general partner will sign off on that and you're admitted to the fund.
Right. Yay.
And you've now closed.
Right.
That's a first closing or a second, whatever it is, when you thought become admitted, and that's a closing.
Right. I see now that they're automating sub-docs.
Sure.
I've filled out sub-docs and there are questions that I just don't get sometimes.
Yeah.
Right. Which is why we need someone like you to interpret and say what it's actually saying.
And we have like at Lowenstein specialists within our IM group who are AML specialists. Right. So like if there's something, I'm a funds lawyer and I look at these things all the time and advise my clients, but there might be very bespoke types of representations from the tax side or from the AML KYC side, where I'm going to loop in specialists to make sure that we're getting to the right place and that our clients are appropriately covered.
Right.
Yeah. Those are the key, main documents, cast of characters, I think. Another piece of setting up your business is understanding where you fall in the regulatory regime. I think that, a lot of managers emerging managers are sort of below like asset thresholds where they might not have to be under full registration with the SEC.
Right.
And that might kick them to state registration, or they are at a level of being like an exempt reporting advisor.
Yeah.
But this is important to understand and know so that you are developing a compliance program that addresses where you are and that you're complying with applicable regulations.
Right.
Because the SEC is no joke.
I've seen the SEC come in 3 months after an emerging manager started.
Yes.
It's like,
It's a new entrant exam.
Yeah.
And you know what? That's kind of the best time. I mean,
Right.
if you're a new manager and you've set everything up right and
Yeah.
you've got a very short operating history, there's not much for them to see other than the fact that you've set up a compliance program that is commensurate with what you are and what you are doing.
Right.
But the key is to, from a compliance perspective, develop policies and procedures that address specifically what you're doing from a business perspective and specifically what's required of you from a regulatory perspective.
Yeah. That makes
And we
sense.
do a lot of that. And, you put in your first filing if you're going to register.
Yeah.
That's your Form ADB. You want to make sure that whatever sort of disclosures are there match going back to the PPM,
Right.
what are in the PPM, so that you have harmony across, what you're telling the market about what you're doing.
Yeah. I've also seen Form PF. What is that? And why is it different from the Form ADB?
Yeah, a Form PF is more of like a finance-driven
Got
filing.
it. Got it.
It's not publicly available.
Got it.
So it's a filing that's required based on your size, either annually or quarterly, depending on, your asset size. But it really is giving the regulator a window into, the way you sort of borrow,
Right. Amount of assets.
the amount of assets, where, in what strategy. And it's technical. And in my experience, it's really driven by the finance team. The lawyers come in to help interpret what the questions are asking.
Yeah.
But I've seen a lot of administrators actually help clients
Yeah.
with that file.
We tried.
Yeah.
We'll get the numbers together.
Exactly.
They'll just say, hey, we need this and that.
Right.
So yeah.
It's a very numbers heavy filing. And it's not that the ADB isn't. The ADB has
Right.
numbers too,
Yeah.
which should tie to the PF numbers. But the ADB has two components to it. It has more of like the number. Part one is more like numbers.
Right.
And then part two is more of like a brochure narrative about the business
Got it.
and a disclosure of risks.
Got it.
Yeah. And so that's the regulatory piece.
Right.
And I think, depending on the place and its needs and its size, you might have a CCO or you might grow into having a CCO.
Right.
People might start off having external compliance consultants. They
Yep.
might rely on their lawyers. There are lots of ways to sort of
Manage
manage that.
Manage that process.
The other thing I would just now, so we kind of covered the universe of like fund entities,
Yeah.
fund documents,
Yeah.
kind of terms that you're thinking about. Just taking a step back also, when someone is launching their fund,
Mhm.
launching their firm, it's important to think about what obligations or restrictions might be applicable to them at that time from perhaps prior employment.
Yeah.
And we help people analyze that as well. So a lot of the times, folks, who were, investors at, another firm have been subject to an employment agreement, which might have restrictive covenants like covenants of confidentiality and non-solicitation of either investors or employees,
Right.
as well as non-competition.
Yeah.
Really important to make sure you know what those are and what they say and how they actually apply to the activities you're undertaking as you think about launching your new business. And it's not, there's the substance of the provisions and then there's what's practically applicable.
Right.
And, I've helped clients a lot think through, specific activities they want to undertake and where they sort of fall on the risk spectrum of what their, existing sort of restrictive covenants say. And so it's not like a one size fits all,
Right.
but good to do because, when you're starting off a brand new firm, you want to do it on the right foot. You don't want to have, any sort of reputational damage and you don't want to have distraction of
Yeah.
potential threat and litigation or something that's going to wrap up, tie up your time
Yeah.
when you're trying to, spend all of your time either fundraising or like actually going out there and sourcing and making a deal?
Yeah. I'm assuming you have a lot of experience with, let's just say the fund started and then they got rid of their counsel. Now you have to interpret someone else's document.
Sure.
Like, how do you put yourself in their head when it's very vague, or, how do you, kind of get to what it was meant to say?
Yeah, I mean, I think a lot of it comes with experience and having seen lots of different provisions over time and seeing how they actually play out operationally. And so that's kind of how you sort of triangulate and conclude. And then ultimately, like, the goal would be, okay, you're moving and your existing drafting is a little bit lacking. Like, maybe on Fund 2, we're going to help you fix this.
Right.
But that goes to that question also about, like, well, what happens if what you do in Fund 1, how does that impact Fund 2? And the truth is, in Fund 1, you might have to do certain things or agree to certain provisions to get the money in the door.
Yeah.
Then you start gaining, the not power shift, but
Right.
negotiating posture can change for Fund 2 because you've been successful, you've started to build a track record, you've proven yourself. Now you've got a little bit more interest and you're institutionalizing a little bit more.
Yeah.
And so you're saying, okay, you know what, like, a lot of investors who come back for Fund 2, they'll run a black line.
Right.
And they look at the
Right.
document
Right.
and they're like, why did this change? You already agreed to this. And you've got to have a real reason as to why, they should still sign up with something that's maybe less favorable for them.
Makes sense.
Yeah.
What else?
What else? Okay. So we were talking about employment,
Yep.
from the perspective of someone who is
Like,
starting.
if you might take that from another firm, protect it, but what about employment, in their own firm?
Good practice to put employment agreements in place.
Right.
A lot of the time people also have arbitration agreements in place, which I think saves a lot of money and kind of, cuts out, potential sort of litigation if something goes wrong.
Right.
Yeah. But
And it does.
yeah, but I think, from an employment agreement perspective, the main thing, and people need to understand this, investors are looking for, to put their capital somewhere that is safe.
Right.
And that, this goes to institutionalizing your business, protecting your IP, and making sure that your employees are bound by something so that they can't harm the firm.
Right.
And so it's not only, it's actually like an investor relations point too, that they can't harm the firm.
Right.
And so it's not only, it's actually like an investor relations point too. I think that people would appreciate and understand. It's a little bit of an expense, but not a huge expense. You kind of get a form of employment agreement in place, and you make sure it's compliant with all the applicable laws to have people sign that when they join.
It protects you. It protects your reputation.
Exactly.
Very smart.
The other thing just to think about at launch time, trademark.
Okay.
Okay.
Yeah.
So that's another thing we do for our clients right off the bat. You've picked a name, you want to get started, that name's available.
Yeah.
You do a search to make sure. And then you might apply for your own trademark so that, it's yours.
Right. You don't want to spend all this time, money, and then someone steals your trademark.
Right.
Yeah.
So we do that. And then I think, just, in terms of just business operations, right? Super important to think about who your service providers are going to be.
Yeah.
And, diligencing them. From a business perspective, like a business risk perspective, but also like a regulatory compliance perspective, like the regulator has an expectation that you're going to go out and, when client information and client assets are being somehow impacted or touched by third-party service providers of your firm, you better make sure you know what they're doing and that you put appropriate protections in place in your agreements, indemnification, representations from them, whatever they are, whoever, whatever's appropriate based on what they're doing. But that's good business, right?
Yeah. Yeah. I mean, you work with forget that. Sorry. I was going to say, like, you work with a lot of people, and you always, people always want to ask you for a service provider and things like that. So you also have to be very careful. You have to vet the people that you're with.
Absolutely. Absolutely. And look, I've had the benefit of having been in-house and seen a lot too.
Right.
And I've seen what's good and I've seen what's bad. And so, and I, was the person who was responsible for doing that diligence.
Right. After all of this, if you had to give the emerging managers, 1 point, when they're starting out and they want to launch a firm or a fund, what do you think that is? What would you say?
I mean, I think that, look, I can speak from the perspective of legal counsel.
Yeah.
And thinking about who you're going to choose to help you with that. Price is a consideration,
Mm-hmm.
but, you don't necessarily want to go for the cheapest option.
Right.
Because long-term, it may wind up being more expensive.
Yes.
So, I mean, I think, that's something just to think about. You should look, and, I actually wrote an article this recently.
Okay.
About how, internal counsel can get the most out of their external counsel relationship.
Right.
Because I've sat on both sides of this now. And I think that's really important. Like, you should be looking for a partner
Mm-hmm.
who's going to really get in there with you and help you problem solve and build your business, as opposed to someone who's just kind of plugging holes in your college for like billing, on just the billable hour. Right. And I think that ultimately that will pay dividends.
Yes.
Like, you want to be thoughtful at the beginning
Mm-hmm.
and not rush and not, people are very excited, and obviously you're getting momentum from investors and all of those things. And you're trying to make everything kind of happen at once to get yourself off the ground.
Yeah.
But it's like, I think on the structuring front, extremely important to get that right. I think when you're taking in seed capital, extremely important to make sure that, like, in 5 years, when you look at this deal, are you going to be okay?
Right. You made the right decisions.
Yeah.
Well, I wanted to thank Courtney Posner for coming here today and basically talking about, if you're ready to launch a fund, you need to talk to someone like Courtney.
Thank you so much for having me.
Thank you. I appreciate it.
Great to chat with you. I was so happy to do this in person.
I know. Thank you so much.